Yes, Mr. Gillies.
Good morning, my lords. Three very short housekeeping points to start with. First, the citation I was looking for from Weavering yesterday was paragraph 90, and that's in the supplemental bundle at page 556. The second point, I've spoken to my learned friend, and like him, I would like to reduce my time for reply to 1 hour. So that I will finish at 4 p.m. today. That leaves both parties their allotted time tomorrow. My lords, I have 9 topics to deal with today. I'll complete my submissions on assumption of responsibility, and then when I move to my cross-appeal, I'm going to take some of the issues slightly out of order. I'm going to take ground 2 of strict liability after assumption of responsibility, and then ground 4, causation and loss of a chance, because both of those topics raise the same questions of finality in litigation, which I'm going to be addressing in the context of assumption of responsibility. So there is hopefully a theme that flows through those 3 topics. So, my lords, coming back to where I was yesterday, I was dealing with Primeo's appeal against the SICA's refusal to allow Primeo to raise the new assumption of responsibility case. And we say that at paragraph 223 of the SICA judgment, so that's page 264, SICA rightly applied considerations as to the need for finality in litigation and made no mistake in refusing to allow Primeo to raise this new case. And my lords, with that, I wanted to take your lordships to Sainsbury's and MasterCard, which we have and hopefully accessible in Supplementary Bundle 1 at page 340. And all of your lordships were involved in Sainsbury's and MasterCard, apart from Lord Kitchen. So I hope I can take the facts very briefly. And the relevant section of the judgment starts at paragraph 227, and that's at page 400.
It's going to take me a moment to find this bundle.
This is, I think, the supplementary hearing bundle. I think it's labelled in our documents.
Supplementary hearing bundle 1.
Yeah. And I'm sorry, which page was it?
It's page 400.
Thank you.
Sorry, I didn't seem to have it. Supplemental hearing bundle, page
400. So, your lordships will recall that in the AAM proceedings, as they were called, the trial judge was Mr. Justice Popplewell. And he held that the MIFs, the multilateral interchange fees, infringed 101 section 1 of the FEU treaty, but the default MOUs were exempt under 101 subsection 3. The Court of Appeal overturned the decision that the default MIFs were exempt because they said that that decision could not be made just on the basis of economic theory, but required empirical factual evidence. And they held that in consequence the claim for exemption before Mr. Justice Popplewell should have failed. Nevertheless, because the Court of Appeal thought that at least part of the exemption claim could have been made good by relevant evidence, they remitted the matter to the CAT to be heard with 2 other matters, with directions that the AAM exemption issue was to be determined by reference to the empirical evidence adduced in those other proceedings. So they remitted in order to allow the question to be determined by new evidence. So very briefly, that's the background. So obviously it's not so much the facts as the principle I'm interested in. So can I pick up the judgment at paragraph 237, which we have at supplement 402, and at paragraph 237, the Supreme Court overturned the decision of the Court of Appeal, saying that, quote, "This offends against the strong principle of public policy and justice that there should be finality in litigation." So we see that in the middle of paragraph 237. And at paragraph 238, the Supreme Court refers to various provisions in the CPR, including the overriding objective, which is replicated in the Cayman Grand Rules, and we can see that at MS 9713, and then commented at the bottom, starting at the bottom of page 402. The higher courts have in a number of respects laid down important and binding principles regarding what justice requires in the context of litigation, and these inform the proper approach to the interpretation and application of the overriding objectives. And then, my lords, to save time, if I may, could I ask your lordships to read to yourselves paragraphs 239 to the end of page 243. So it's just a page and a half. If I said I didn't want to hurry your lordships, I'd be lying. So, my lords, in our submission, the Court of Appeal correctly applied those principles in refusing to allow Primeo to raise new arguments on assumption of responsibility for determination on remission by a first instance judge. And the key points that we would pick out are from Henderson and Henderson, that we see at paragraph 239 at letter F. And Henderson requires the parties to, quote, "bring their whole case before the court so that all aspects of it may be finally decided once and for all. In the absence of special circumstances, the parties cannot return to the court to advance arguments, claims or defences which they could have put forward for decision on the first occasion but failed to do so." And in one sense, the corollary of that is the point that is made at paragraph 242, namely that, quote, "in the adversarial system of litigation in this country, the task of the courts is to do justice between the parties in relation to the way in which they have framed and prosecuted their case." And in our submission, one sees the consequence of that in what are the principles that underlie what the court says at paragraph 240, namely that where there has been a fair trial, where parties have been on notice as to the issues and have had an opportunity to frame their case as they see fit, you don't get a second bite of the cherry. Now, as I've indicated, the principles of finality in litigation are also important to the second ground of my cross-appeal and to causation and loss. But for the present time, I'll just focus on assumption of responsibility. And the first key point that we make at paragraph 132 of our case, which is at page 2392, is that there was nothing unexpected in the judge's finding that R2's custodial responsibility might only start in August 2002 when R2 signed the custodial agreement with Blimis. Indeed, you can see that even from the excerpts of the transcript, which my learned friend quotes at paragraphs 176 and 177 of his case. That's at page 2300. And the reality is that practically from the first day of the trial, it was clear that the judge doubted Primeo's case, that R2's custodial liability for Blimis assets began, as Primeo contended, in 1996. And frankly, that's hardly surprising, because there was no written sub-custody agreement between R2 and Blimis at that stage. So, as one can see from the excerpts quoted by my learned friend, the judge was onto this point straight away. And at the same time, it was also perfectly obvious from early in the trial that the judge did think that a sub-custodial relationship arose between R2 and Blimis on execution of the 2002 sub-custody agreement. So it's not open to Primeo to say that they did not get a fair trial because they were taken by surprise by this point. Indeed, in closing, they expressly argued August 2002 as an alternative start date for custodial responsibility. And in that context, can I ask your lordships to look at Primeo's closing at trial? And we have that in the hearing bundle, page 1727. And the passages that I'd ask your lordships to review in more detail in due course are paragraph 697 through to paragraph 704. And there, in the alternative to arguing that R2 had custodial liability for the Blimis assets from inception, they argued that custodial responsibility began in August 2002 on the execution of the sub-custody agreement. And just because of pressure of time, can I jump to paragraph 704, subparagraph 1, which we have at 1730, where it said that in the circumstances explained above, so that's all about the execution of the 2002 sub-custody agreement, there was an implied agreement between Primeo, Blimis, and D2 So, in other words, they were suggesting that there was an implied agreement that came into effect in August 2002, as a result of which subcustodial liability arose, and that, of course, is exactly the implied tripartite agreement that the judge found in, I think it's paragraph 172. So, my lord, that's how it was put in closing. Then in oral closing, it was clear from how Primeo put its case that there was uncertainty as regards when the custodial strict liability period began. And in that context, can I ask your lordships to go to MS 1903, which is day 41. It's page 66, line 20. So this is actually in the context of Primeo's strict liability claim. And there my learned friend said, my lord, so far as the strict liability claim is concerned, the second defendant is simply liable for the net investments placed with Bilmis for investments which have been lost as a result of the acts and emissions of Bilmis. So it is simply a case of cash having gone into Bilmis, having been lost, and we say the second defendant is liable for loss over whatever period of time your lordship considers it's appropriate to look at. Because they were fully aware it was their case in the alternative that custodial liability started in August 2002.
So, just to be clear, the word investments is being used to refer to the cash payments.
Yes,
right.
Yes, exactly. Yep. So that's the second point that comes out of this, that and it's frankly not disputed, that at trial, their strict liability case was being put on a cash basis, namely net investments, not fictitious securities.
Yes, exactly. Yeah.
But the critical point, just at the moment, and that obviously is a very important point, is that they were alive to the fact that custodial liability might not start until August 2002. Indeed, that was expressly their written case in closing. And finally, just to reinforce that it was Primeo's alternative case that strict liability began in August 2002, can I ask you to look at Primeo's closing at trial, this time MS 1894, day 40, page 3. And it's at lines 21 to 24, where again we can see the same point being made. So, and my lords, the Court of Appeal rightly recorded in its judgment that Primeo put this as its alternative case in closing. And we can see that at paragraph 78 of the Sicker judgment, which we have at page 213. So, paragraph 78, page 213, Primeo submitted in closing that Bilmis was R2's sub-custodian continuously from the inception of the 1993 custodian agreement down to the Herald transfer. If this were wrong, Bilmis became R2's sub-custodian on the execution of the 1996 brokerage agreement, and if this were wrong, Bilmis became a sub-custodian of R2 when the 2002 sub-custody agreement was concluded. So, there really can be no dispute, we say, that they were putting August 2002 as being the alternative start date. And despite it being obvious that R2's custodial liability might only start in August 2002, Primeo chose to frame its strict liability claims on a net investments or net cash basis only. It was only as regards its damages breach claim that it sought to value its claim by reference to the fictitious value of the securities, the point my Lord Reed made. Now, that was the litigation choice that Primeo made. And as Henderson makes clear, if they wanted to bring forward the much more expansive claim for fictitious profits as part of their strict liability claim, they should have done so at trial. They chose not to do so. They framed their strict liability claim solely by reference to the net cash basis received during the strict liability period. And having asserted a liability and damages case in that way at trial, we say that Sicker was right in saying that they don't get a second bite of the cherry. It offends the strong principle, quote, to use the phrase in Sainsbury's, of finality in litigation. The second point we make, and this is at paragraph 134 of our case at page 2393, is that it's simply not the case that it was always envisaged that there would be a further quantum trial. Mr. Justice Jones had heard all the quantum arguments and evidence during the trial. The only thing that was envisaged was that the experts might need to rerun the numbers in the quantum model once the judge had decided on the relevant inputs. And those inputs, even there, they only related to the breach negligence claim in relation to Bilmis's loss of profits claim. Primeo's loss of profits claim. So it didn't impact the strict liability claim. And indeed, my learned friend yesterday at day 2, page 28, seemed to accept that all that was required in respect of strict liability was a calculation. And since all of the cash-in, cash-out figures were before the court, that's absolutely right. Once you've selected the appropriate period, you just need a calculator to calculate what is payable or not. The third point we make, which is at, again at page 2393, is that we say it's irrelevant that it was only in our skeleton argument, served 3 months before the Sicker hearing, that we pointed out that Primeo was a net redeemer during the strict liability period. That was not something we were required to plead separately. We had already denied loss. Nor is it something we were obliged to bring to Primeo's attention. It raised no new issues of fact, expert evidence, or law. The schedule of cash sent to and received from Blimis had been agreed by the experts 6 months before the trial. So the judge's only task was to quantify the loss of cash during the relevant period. And that's simply a matter of arithmetic. In any event, we say this is of no real relevance. If Primeo thought R2's strict liability responsibilities extended to the profits on the fictitious securities that Bilmis held on the 7th of August 2002, then they could and should have run that in addition to their net cash claim. Self-evidently, if it's right, it would have given Primeo a much larger claim than one pursued just on a net cash basis. But despite that, Primeo chose not to do so. And if they made that decision without working out how much their net cash claim was worth, well, that is their litigation choice. So we say that there was no error on the part of SICA in refusing to allow the assumption of responsibility argument to be raised for the first time on appeal. On the contrary, for the reasons that we give at paragraph 137 to 140 of our case, that's at page 2393, we say the SICA's decision was obviously right. And there are two short points we make. First, the question of assumption of responsibility, and that's the issue, does not arise in a vacuum. The question of assumption of responsibility is always in relation to what? And SICA was right in the second sentence of paragraph 223 that the scope of that duty question had to be determined at trial by reference to the relevant evidence and was not one that could be raised for the first time orally on appeal. The second point that we highlight at paragraph 140 is that had the new point been taken at trial, it would have affected the evidence and the course of the trial. And we make 2 points in particular. Firstly, Primeo's assumption of responsibility argument regarding fictitious securities would likely have led to further Luxembourg law evidence. And your lordships will recall that the account that we're talking about, the 092 account, is a Luxembourg law account. The implied tripartite agreement is a Luxembourg law agreement. Under Luxembourg law, evidence of subjective intent is relevant, and all of that would feed into the question of whether there was assumption of responsibility. The second point that we make is that it may well have affected the trial judge's view of the implied tripartite agreement. Because Primeo had only pursued a net cash claim, the trial judge did not have to ask himself the question, which would then arise, namely whether the parties can have intended that R2 would assume liability for the fictitious securities that pre-August 2002 Bilmis held for Primeo and were not delivered into Bilmis's sub-custody for R2. And as Lord Justice Burt observed in the SICA hearing, Primeo's argument was counterintuitive. Now, my Lord Sales asked me yesterday whether Primeo's case was based on estoppel. My Lord, the answer to that is no. If your lordships will have seen that there were 5 notes that were sent to the Court of Appeal on this issue during and after the hearing, and if necessary, we'd ask your lordships to read those. Those are MS 2056, 2114, 2124, 2136, and 2144. And in none of Primeo's notes is the case being put by way of estoppel. And frankly, that's one of the problems, that because it's an unpleaded issue, obviously an unevidenced issue, apart from the notes that we've been provided, we don't really know how Primeo seeks to put its case. So the board read those notes, and they came to the conclusion that they did, that requirements of finality in litigation meant that Primeo should not be entitled to raise this new point. And we say they made no mistake on that. It was the correct decision. Finality in litigation dictates that the respondent should not be, quote, oppressed by successive suits, to use the terminology in Barrow, quoted in Sainsbury, by being referred to embark on a new round of litigation on a new issue with the possibility of further rounds of appeal. The new matters that Primeo seek to introduce relate to August 2002, so some 20 years ago. Despite Madoff's admission of fraud in December 2008, Primeo did not issue its claim until May 2013. After a massive discovery exercise and the parties adducing thousands of pages of witness statements and experts' reports, the 4-month trial with 27 witnesses ended in February 2017, and we are now another 4.5 years down the appeal process. We do suggest that the, quote, strong policy of finality in litigation is particularly important in a case of this nature. My Lords, I'm now going to move to the first ground of our cross-appeal, so to start on the first of my remaining 8 topics. So this is ground 2, and we deal with this at paragraphs 170 to 185 of our case. So that's page 2402. And Primeo reply in their reply submissions at paragraphs 19 to 22, and that's at page 2320. And clearly this issue is closely connected with the issue that we've just been talking about, assumption of responsibility. Because as the board knows, the SICA remitted for hearing 2 new grounds. That's the Clayton case, what we've described as being Clayton case, first in, first out, or secondly, the new appropriation case. Now, I'm not going to get into the merits, but just in the context of the Clayton's case suggestion, we'd invite your lordships to look at paragraph 175 of our case, which explains that Clayton's case has nothing to do with the assessment of damages. Clayton's case is effectively, as you know, a first in, first out rule applied to insolvency. It's not referred to in Chitty or any of the contract books in terms of calculating damage. It's a red herring, but it's suggested that this should be remitted. So your lordships know the circumstances in which this issue arose. Of course, again, it's a consequence of the fact that we pointed out that they were a net redeemer during the strict liability period. So that's the background. Can I take your lordships to what SICA said, and we can pick this up at paragraph 227 of their judgment. So we have that at page 265. And at paragraph 227, it's the second sentence. Since we are not in a position to decide if the broker custody account was a running account or whether the application of Clayton's case would be contrary to the party's intentions, or whether in the circumstances of this case, Primeo is entitled to appropriate redemptions as it sees fit, the question as to appropriation in general and whether the rule in Clayton's case was to apply would be referred to the judge assigned to deal with the assessment of damages. So SICA was saying that they were not in a position to decide the issue, but it had to be remitted. Now, it follows from that, we say, that SICA implicitly conceded that the new case, or the new cases, did not raise pure points of law that could be decided on the evidence already before the court. That's necessarily implicit, because otherwise SICA would have been able to decide the points without the need to remit. So, although SICA did not expressly state that the parties would be able to adduce fresh evidence on the new points at the remittal hearing, we say that necessarily follows. And we've set out at paragraph 182 of our case, this is page 2405, some of the further evidence that would be required. And Primeo's reply case at paragraphs 19 and 20, that's page 2320, does not suggest that the parties would be barred from adducing any such evidence. So I don't think there is any dispute that this is what SICA intended. As we say, it's implicit. With that, can I just highlight the key points that we make at paragraphs 177 to 181 of our case as to why we say SICA was wrong to permit Primeo to raise the new case and then remit them for determination by reference to fresh evidence at a further trial. And my Lord, I think I can take the first and third of our points together. So I'm now at paragraph 177 of our skeleton, which is page 2404. And at paragraph 177, we say that since the agreed evidence established that there was no loss on the claim as Primeo had framed it, SICA ought to have simply assessed the damages at zero. The third point which we make at paragraph 179 is this, that if the trial judge had not erred, as SICA held he did, he ought, Mr. Justice Jones, ought to have found that R2 was strictly liable, but then by reference to the agreed figures before the court, he ought in any event to have assessed the damages at zero. And at that point, Primeo would not have been able to advance the running account or the appropriation case, and Primeo should not be put in a better position just because there's been an appeal. And my lords, in that context, we say the situation is very similar to the situation that the Supreme Court in Sainsbury's and MasterCard considered. And in that context, could I ask your lordships to go back to Sainsbury's and MasterCard? So that's the supplemental bundle. It's pages 404 and 405. And if I could now ask your lordships to read to yourselves again, if I might impose, paragraph 244. And, my lords, in our submission, the only real difference between the situation that the Supreme Court was considering there and the one before the court in this action is that in Sainsbury's, the new evidence would be adduced I'm sorry, I'll start again. The only difference is that in this action, the new evidence would be adduced in a further hearing. Whereas in the Sainsbury's case, the further evidence would be the evidence that had already been adduced in proceedings to which Sainsbury's was not a party. But that difference is of no relevance to the point that the Supreme Court made. Popperwell J and Jones J, had they not made the mistake identified by the respective appellate court, ought to have applied the evidence before them and dismissed the claim.
I mean, in Sainsbury's, it would have been new evidence against Sainsbury's.
Yes, but the point that the Supreme Court was making is that if Mr. Justice Popperwell had not made the mistake he made, in other words, relying upon economic theory, but had asked himself what is the cogent evidence, he would have said there is no cogent evidence, and therefore I must dismiss the claim. So it's looking at the sort of counterfactual in terms of the first instance hearing.
Yeah, sorry, I probably didn't make myself clear. I was making a point supportive of you that if you look at it just
I'm sorry, yes.
Against
yes.
that particular defendant, I think it was wait a minute, I've lost track whether it's Sainsbury's or AAM. Anyway, against that defendant, that evidence had never been adduced, so it's going to be new evidence against them.
It's fresh evidence, and in one sense even worse, because it's evidence that they've not even been able to test because it was adduced in other sets of proceedings. But your Lordship is absolutely right. The basic point is it would be fresh evidence. So coming back to the point, Popperwell J and Jones J, had they not made the mistakes identified by the relevant appeal courts, ought to have applied the evidence and dismissed the claim. And as the Supreme Court said in paragraph 244, quote, "It is difficult to see how it could be right for the Court of Appeal to produce a different outcome by reason of the adventitious circumstance that AAM had to go through the proceeds of appeal to arrive at the result it was entitled to have achieved at first instance." So, my Lord, that's exactly what's happening here. My Lords, the second point that we make is that the running account case and the new appropriation case were clearly new points being taken for the first time on appeal. Now, of course, these issues wouldn't arise on Primeo's primary case, namely that Blimis was Primeo's sub-custodian from inception. But as I've shown you, Primeo had an alternative case, which they expressly relied upon, that the sub-custodial liability, the strict liability, started in August 2002 on execution of the sub-custody agreement. So I'm not going to go back through all of that evidence, but again, in no sense can Primeo suggest that they were taken by surprise by the fact that the judge reached the conclusion they expressly invited him to reach. And so it follows in our submissions that if there were any appropriation arguments Primeo wished to raise, it could and should have raised them at trial before Mr. Justice Jones, which was a trial of all of the issues on liability and quantum. My Lords, I've already made the case, I've already made the point that it was never envisaged that there should be a further quantum hearing, so I'm not going to repeat my submissions on that. I should briefly respond to what Primeo said in its reply case at paragraph 22, subparagraph 1, which is at page 2321. And here they refer to the quantum experts' joint memorandum, suggesting that quantum was only calculated from 1994. My lords, the point is misleading. The quantum experts and memorandum and their separate reports were only dealing with the damages claim on breach, for which they set out various hypothetical withdrawal dates. That was not the evidence relevant to the net investment strict liability claim. The evidence in relation to that were the cash schedules that had been agreed between the experts 6 months before the trial. And as I've indicated, once the appropriate period was determined, all that was required was the arithmetical calculation by reference to that schedule. So the judge simply needed a calculator. He didn't need further expert evidence. Now, in its reply submission, and we see this at paragraphs 19 and 20 of Primeo's reply, which is at page 2320, Primeo's main submissions are directed at the suggestion that the respondents have, quote, seriously mischaracterized the procedural history. That's not so. In our submission, it's Primeo who are seeking to mischaracterize the position by pretending that they were not on notice that the judge might find that custodial and thus strict liability began in August 2002 on the execution of the sub-custody agreement. It's Primeo who are seeking to mischaracterize the position by suggesting that they had not formulated an alternative case directed to that exact situation, or that somehow Primeo did not make submissions on how loss should be quantified in that alternative situation. The judge correctly understood and recorded that Primeo's case at trial was the net investments case, and we see that at paragraph 172 of the judgment at page 98. So Primeo, in seeking to raise the Clayton's case point and the new appropriation case, was seeking clearly to raise a new case for the first time on appeal that we say could and should have been raised at trial. The next point we make...
Could I ask for a reference, don't need it now, to the cash schedule at some point? Just
yes, I'm
so
sorry,
it's possible to have a look at it.
It's in the hearing bundle. My Lord, the next point which we make in our case, which is we've described as the fourth point at paragraph 180, is that the SICA's decision to allow Primeo to take these new points, but then to remit them because of the need for fresh evidence, was not guided by the relevant principles of law. And we've set out what we suggest the relevant principles are at paragraph 180 of our case at page 2405, and I've taken your lordships to Sainsbury's. We do not suggest, of course, that SICA needed to recite the cases, but what is necessary is that one can see from their reasoning process that the correct principles have been applied. In fact, if one looks at the SICA's judgment at paragraph 227, which we have at which we have at page 265, if your lordships read paragraph 227, in actual fact, the Court of Appeal give no reasoning as to why they should remit. They simply say, since we're not in a position to decide if the broker custody account was a running account, I don't really need to read the rest, the question as to appropriation in general and whether the rule in Clayton's case was to apply would be to refer... I'm sorry. Can I start at the beginning of paragraph 227 and just ask your lordships to read paragraph 227 to yourselves? So, in the first sentence, the SICA says, if the overall outcome of this appeal were that Primeo had established an entitlement to damages on its strict liability claim, there would be an order that the damages were to be assessed by a judge sitting in the financial division of the Grand Court. Just stopping there, even if SICA could not do the arithmetic for themselves, that hearing would take 1 minute, because the agreed evidence showed that during the relevant period, Primeo was a net redeemer. And so the evidence, and so any judgment would have to be for zero. And in any event, SICA made a finding that Primeo was a net redeemer, because Primeo had conceded that fact, and we can see that from paragraph 224. So that first sentence is wrong. In the second sentence, paragraph 227, SICA say that, quote, since we are not in a position to decide the new issue, let's call it that, they will remit them for a further hearing. But that since, we say, is a legal non sequitur. That's the Sainsbury's and MasterCard point that I've already made. The decision should have been made on the basis of the existing evidence, not by ordering a further hearing on new evidence. So, such reasoning as the Court of Appeal did apply, we say is wrong. So the only reasoning that they provided, so we would summarize it in this way. In fact, the Court of Appeal provided no reasoning to explain why, despite the law being very clear, Primeo should not be held to how they chose to formulate their case, or why, despite the requirements for finality in litigation, Primeo should be permitted to raise new legal points that required fresh evidence for determination. So, in our submission, we say that SICA clearly erred as a matter of law, and that this board should exercise its discretion afresh. And the point that we make at paragraph 181 is that if the law is correctly applied, the Court of Appeal ought to have refused Primeo to raise the new issue. I don't want to repeat myself, but they'd had a 4-month trial on quantum and liability. Primeo had put forward an express alternative case of a start date on August 2002, but they decided not to take these points. The new points would require fresh evidence, and we say that the requirements of finality in litigation require that Primeo should not be allowed to raise these further points, necessitating a further evidential hearing. My Lords, we've set out briefly at paragraph 182 the further evidence that we say would be relevant. I've already touched upon that in the context of assumption of responsibility. So I won't go back to that. So, my Lords, these issues, if they were to be raised, they should have been raised at trial so that they could have been subject to pleadings, evidence and submission. The important point is that they don't just raise issues of quantification in the sense of number crunching. And so it's in that context that the board is asked to set aside the SICA's decision, remitting Clayton's case and new appropriation to a fresh hearing. My Lord, I'm now going to, as I said, move to causation and loss of a chance. And I'm taking this now because we say it too raises finality in litigation considerations. And my Lord, we deal with our case on causation, loss of a chance at paragraphs 228 to 271 of our case. That's page 2420. And Primeo's reply is in their reply submission, paragraphs 44 to 86 at page 2329. And as your lordships will have seen from our case, we identify 4 discrete grounds of appeal, but I'm only going to speak to 3. First, what we label at paragraph 236 of our case, the new loss of a chance argument. And in short, we say SICA erred in allowing Primeo to advance its loss of a chance argument for the first time on appeal when determination of that issue would require further evidence and a new hearing. We say SICA failed to apply the relevant principles regarding the need for finality in litigation. The second point we make, which starts at paragraph 248, is what we've termed the reinvestment argument. And we say that SICA was wrong to overturn the trial judge on his finding that the directors would have reinvested the monies withdrawn from Bilmis into another Madoff feeder fund. And we say that was a decision which was open to the judge on the materials before him, once one has the nuanced understanding that the trial judge had, and that the SICA erred in preferring their own views to his. The third point we make is what we've identified as the wrong counterfactual case. And we say that SICA erred in identifying and applying the wrong counterfactual to Primeo's new loss of a chance case. And we deal with that at paragraph 258. The fourth point we make is what we've termed the R1 loss of a chance case. We deal with that at paragraph 263, and we just rely upon what we've said there. I'm not going to speak to that. So can I start with the new loss of a chance case? Namely that SICA was wrong to allow Primeo to raise the new loss of a chance case for the first time on appeal when determination of that issue would require further evidence and a new hearing. And particularly in the light of some of Primeo's reply submissions, I need to start by showing you, firstly, how late in the day Primeo raised what's become known as auditor causation. And secondly, and that's relevant because that's the springboard to the new loss of a chance argument. And secondly, I need to amplify the continuing ramifications of that. Now, we deal with the position at trial at paragraphs 229 to 233 of our case. That's page 2420. And I'll deal with this as quickly as I can do. We start by explaining Primeo's causation case as put in opening. And at 229 subparagraph 1 of our case, we explained that Primeo's causation case on opening was hopeless. It was based on the evidence of a Mr. O'Neill, one of the former directors, who tried to say that the directors knew nothing about single source reporting or triple function risk, and that if only the respondents had told the directors, they would have withdrawn immediately. It was also based on the hopelessly flawed legal proposition that the knowledge of Primeo's investments advisors, BAW, was not attributable to Primeo. So by the time of closing, Primeo's causation case required emergency surgery. In consequence of the evidence during the trial, Primeo accepted in closing that there was equivalence of knowledge between Primeo's and the respondents. So they knew of single source reporting, triple function risk, the fact that this was all being done on the basis of unverified evidence sourced from, unverified information sourced from BILMIS. It was clear that Mr. O'Neill's evidence was not credible, and the judge concluded that he could not attach any weight to it. We see that from the judgment at page 265. It was also clear that the investment advisor's knowledge was attributable to Primeo. So as we explained at paragraph 229, subparagraphs 2 and 3 of our case, the emergency surgery that Primeo came up with during closing was 3 new causation cases. First, administration causation. Second, custody causation. And thirdly, auditor causation. Now, Primeo no doubt hoped that their new causation theories would mean that the question of what the directors did or would not have done would have been of less significance. But as the judge rightly held, none of the 3 theories completely bypasses the question of what Primeo's directors would have done. Now, for present purposes, I do not need the board to focus on administration causation or custodian causation. I don't need you to focus on that. And that's because they do not give rise to any loss of a chance argument. On both those theories, auditor causation and custody causation, causation is determined on the basis of balance of probability, and the trial judge rightly dismissed them. So I only need the board to focus on auditor causation, because that's the springboard to loss of chance. Now, a trial, as you know, the trial judge considered auditor causation on the basis of balance of probability, because that's how Primeo had put its case, and the judge dismissed that causation case. However, before the Court of Appeal, and for the first time, Primeo suggested that auditor causation should be decided on a loss of a chance basis. Now, the fact that auditor causation was not raised until closing has the obvious consequence that there was no factual or expert evidence that had been adduced as to what EY might have done had the custody confirms not been provided. Since the point was not raised until closing, it was not defined in the pleadings as an issue, and so neither party had called any factual or expert evidence directed to what would have happened if the custody confirms had not been provided. And that, we say, still has very serious ramifications. For it meant that the inevitable consequence of SICA's decision to allow the new loss of a chance point to be taken was that there had to be accompanying orders for further evidence at a further hearing. Now, in Primeo's reply, and we see this at paragraph 65, at page 2355, Primeo seek to suggest that at trial, evidence was adduced on order to causation. Well, that's simply wrong, and it ought to be corrected. And there was no evidence on order to causation because the point wasn't raised until closing. So with that, can I come to the Court of Appeal's judgment, and we deal with this in our case at paragraph 231, at page 2422. And in terms of the loss of a chance argument, the key paragraphs of the SICA judgment are paragraphs 332 to 335 and 342. So that's page 306 and 311. So if I could ask your lordships to look at that. And there are just a couple of points that I'd like to draw out from the SICA's judgment. First, SICA recognised that this was a new point not raised until Primeo's Court of Appeal skeleton. We see that from paragraph 332. Primeo had raised an entirely different loss of chance point at trial. But that was not as regards the likelihood or otherwise of EY refusing to give a clear audit opinion. It was to do with whether Bilmis had sufficient funds to meet redemption requests. So it was a new point first raised on appeal. Interestingly, however, it shows that Primeo were aware at the time of trial of the loss of chance doctrine. And it's a point I'll come back to, but what we say is that it's striking that even now, Primeo has not explained why it did not raise auditor loss of a chance earlier. The second point that I wanted to emphasise is that before the Court of Appeal, Primeo was asking the court to determine the loss of the chance. And they said the loss of a chance should be assessed at 75%. And we see that at paragraph 199 of Primeo's appeal skeleton at page 1958. So it was no part of Primeo's case that the point should be remitted to a new hearing to be determined on the basis of fresh evidence. Maybe that proposition was too bold even for Primeo. SICA, we say, rightly decided that it could not itself determine the loss of the chance because there was no evidence on the point. However, in our submission, in remitting the matter for determination by reference to further evidence at a further hearing, we say that SICA failed to have any proper regard for the requirements of finality in litigation. And in terms of the new evidential and legal issues that would arise on remittal, we summarise that at paragraph 233 of our case at page 2424. Now, but particularly in the light of something we see in Primeo's reply reply submissions, there's one point I should get out of the way now. As you will see, we say that SICA was wrong to remit, and we also say at paragraph 237 of our case that the trial judge was wrong to allow auditor causation to be raised at trial. Now, I don't need to take that as a separate issue, and I'm not going to. The importance of it is that the ramifications of that decision, namely that there's no expert or factual evidence on what would have happened had the custody confirms not been issued, those ramifications are still being felt, as shown by the fact that SICA, when they allowed the new point to be taken, ordered remission for new hearings. Now, in their reply at paragraphs 48 to 51, Primeo seek to make 2 points as regards the position at trial, and I can explain briefly why they're both wrong. First, Primeo seek to suggest that the reason auditor causation only arose in closings was because of the respondents' disclosure failings. And in support of that, they refer to a chronology that was provided to the Court of Appeal. That's at MS 2062. We served a chronology in response, which is at MS 2092, and I'd invite the court to look at that in its own time. That chronology shows very clearly that the bulk of the custody confirm documentation relied upon by Primeo at trial was disclosed in March 2015. The custody confirm document Primeo relied upon for the year 2005 was disclosed on the 31st of March 2015. The custody confirm letter for the year ending 2006 was disclosed on the 31st of March. It clearly stated that R2 was sending blemish statements to EY. The internal HSBC emails about EY's concerns were also disclosed in March 2015, and indeed they even feature in the re-amended pleadings served in July 2015. And of course, Primeo knew about this at the time, because EY met with Dr. Farno and BAWFM in 2005 to discuss it, although we don't actually know what was discussed. The reality is that Primeo had no interest in the custody confirmations while their causation case was based on the evidence of Mr. O'Neill. And it was only after the close of the evidentiary hearing when Primeo realised that their causation case required emergency surgery that they changed tack to order to causation and custody confirms. The second point that we make at paragraph 51 of our reply, which is at page 2331, sorry, I'll start again. The second point Primeo seek to make at paragraph 51 of their reply, which is at page 2331, is that the custody confirms were in issue and were extensively addressed during the evidentiary hearing. However, as Primeo is forced to admit at its footnote 13, so that's page 2331, the custody confirms were only referred to in opening as part of Primeo's estoppel case. So what they were saying is that, for example, having issued the custody confirms, we were stopped from denying that we were the custodian. And that was the argument that the judge accepted at paragraphs 165 to 167 of his judgment, and we see that at page 94. So the basic point is this. The estoppel argument operated from the basis that the custody confirms were issued. The order to causation case operates on the premise that the custody confirms were not issued. So, order to causation raises the question of what would have happened then. And on that, there was no evidence adduced because order to causation was not raised until closing. So there is nothing in either of the points Primeo seek to make. There was no evidence, factual or expert, on the key issues that would arise on order to causation had the custody confirms not been issued. So with that by way of background, can I move now to why we say SICA erred in allowing Primeo to raise its new case and then remit? And if I can take your lordships to paragraph 241 of our case. So that is at page 2426. And there are 5 points that we make, most of which, in actual fact, arise out of points the Court of Appeal made in purported justification for its decision. But the first and the overarching point that we make, and this is paragraph 242 of our case, is that SICA disregarded or failed to apply well-established law on raising new points of appeal and the associated requirements for finality in litigation. And I've already referred to how the Supreme Court summarised the law in Sainsbury's and MasterCard on the need for finality in litigation in the context of remitting new points for appeal. I'm not going to repeat what I've already said. The basic point is that courts decide disputes according to how the parties decide to frame them, and that all relevant points have to be brought before the court at the same time. In short, you don't get a second bite of the cherry, especially where the new point requires fresh evidence or would have affected the course of the trial. Now, as I've said, Primeo was not bold enough to suggest to the Court of Appeal that the matter should be remitted. They simply asked the Court of Appeal to decide the point, which the court rightly concluded it couldn't do because there was no evidence. But in deciding on its own motion to remit the point to a new evidentiary hearing, we suggest that the Court of Appeal lost sight of those strong requirements of public policy and principle in favour of finality in litigation. And if the Court of Appeal had had those principles in mind, we suggest that one of the first questions it would inevitably have had to ask is, why did Primeo not raise loss of a chance earlier? Even when Primeo chose to raise order to causation at trial on closing, it did so on the basis of balance of probability, not loss of a chance. That, we suggest, was a clear litigation decision that Primeo made. It was not a decision that was made out of ignorance, for, as I've said, Primeo had already deployed a different loss of a chance argument. And at footnote 140 of our case at paragraph 243, at footnote 140, which is at page 2427, we suggest that it's not difficult to see why Primeo chose to frame its case in this way. Its desire for jackpot damages, if I could use that phrase, meant that it preferred the all or nothing balance of probability approach as compared to a percentage discount on the basis of a loss of a chance approach. Well, having made that decision, having gambled and lost, if I can put it in that way, we say the principle of finality in litigation clearly indicates that Primeo is not entitled to a second chance at a further hearing on a new issue of law determined by reference to further evidence. My Lords, the second point that we make at paragraph 243 is really just a further indication of the fact that the Court of Appeal did not apply the relevant law. Had it done so, the Court of Appeal would have had to have regard to issues of fairness. They'd have had to consider the points that we've made by reference to Sainsbury's and MasterCard. They would be asking if Primeo had sought to introduce its loss of a chance at trial, that application, they should have concluded, would have been bound to fail. So the evidence is closed. There was no relevant evidence before the court against which the court could determine the percentage chance case if EY had not issued a clean audit. And as made clear in the Sainsbury's case, a party should not be put in a better position just because the matter goes to appeal. Now, in response to this second point, Primeo asserts, and we see this in its reply at paragraph 61 to 64, and that's page 2333, they make what we suggest are two untenable propositions. First, at paragraph 61, that's page 2333, Primeo suggests that, quote, there is no basis to suggest that, had the loss of chance argument been advanced at trial, there might have been additional evidence. Well, we say that's a remarkable proposition. We'll wait to see what Primeo says in response. But with respect, it's self-evident that had the point been pleaded, expert evidence would have been adduced on what a competent auditor would have been required to do absent a custody confirm. And what the judge held He held that Primeo had failed to prove its auditor causation case on the balance of probability. And that's wholly consistent with the fact that there was no relevant evidence before the court on the trial in relation to this point. And suffice it to say, it's clearly not the opinion of the Court of Appeal that there was sufficient evidence before the court to fairly assess the loss of the chance. Had there been, the Court of Appeal would have accepted Primeo's invitation, decided the point, and not remitted it. My Lord, the third point that we make at paragraph 244 of our case, which is page 2427, is really just responding to a point that the Court of Appeal sought to make in justification of permitting the new point to be taken. And at paragraph 333 of the Court of Appeal's judgment, in purported justification for allowing the new loss of a chance case to be raised, the Court of Appeal said, quote, "This was not a failure to plead a cause of action. The correct approach to causation in a counterfactual situation is a matter of law, and it's not generally necessary to plead matters of law." So that's what they say in the middle of that paragraph. My Lord, I don't need to dissect each of those statements. The basic point is that they do not lead to the conclusion that there is no need to plead or prove facts relied upon in support of a loss of chance case. Of course you have to. It's difficult to know how there could be a fair trial if you don't. To put it another way, and this is the point we make at paragraph 244 of our case, loss of a chance is not something which a party is entitled to raise for the first time after close of evidence, without reference to a pleaded case and without evidence, let alone for the first time on appeal. In that context, however, we say that in any event, and with respect to the Court of Appeal, whatever point they are seeking to make about a new loss of a chance case only raising a point of law, that point is falsified by the order they made for the issue to be remitted for determination by reference to further evidence. So the order that the Court of Appeal made recognises that the new loss of a chance case does not only raise a point of law that can be fairly determined by reference to the existing evidence. It's a point of law which can't be determined save by reference to a further evidential hearing. And that's why we say, in consequence, if the Court of Appeal had applied the relevant principles of finality of litigation, they ought to have denied Primeo the right to raise this new point. The fourth point that we make at paragraph 245 of our case is responding to the Court of Appeal's attempt to justify its decision by reference to how the Court of Appeal in Maples, Allied Maples, dealt with loss of a chance. And your Lordships can see this is paragraph 334 of the Court of Appeal's judgment. And for present purposes, there are really only two short points I need to emphasise, which shows that Allied Maples does not provide a precedent for allowing the loss of a chance case in this argument, in this case, to be taken for the first time on appeal. And the first point we make is this, that in Allied Maples, there had been an order for a split trial, with liability and causation being decided first, with quantum being decided at a later hearing. But that was not the case here. By the time of the Court of Appeal's decision, the Sickers' decision, there had already been a 4-month trial on liability and quantum, at which Mr. Justice Jones had heard all of the relevant evidence and considered all of the submissions that the parties wanted to make. In contrast, in Allied Maples, the quantum hearing where the loss of a chance was remitted to be determined was always planned and was still to take place. And so, as a result, Allied Maples did not raise any issues as regards finality of litigation. In contrast, the fact that the quantum trial in the Primeo case had already taken place meant that considerations of finality of litigation ought to have been front and centre to the court's consideration. Now, as I've mentioned, it wasn't Primeo's case that the Court of Appeal should remit. They were just asking them to decide it. The decision to remit was the Court of Appeal's decision on its own motion without having heard submission. And as a result, it appears that the Court of Appeal missed the crucial distinguishing feature that Allied Maples concerned the trial of a preliminary issue. And certainly there's nothing in the Sickers' description of Allied Maples in their judgment at 334 and 335, which would suggest that they were aware of this critical distinguishing feature. My Lord, the second point we make in respect of the Sickers' reliance upon the Allied Maples decision is that at the time of the Allied Maples decision, the loss of the chance doctrine was relatively unknown. McGregor on damages describes it as a giant leap forward. It was a landmark decision. As a result, it might be thought understandable why the loss of a chance doctrine was not deployed at stage 1 of the split trial. That's not the case here. Primeo knew of the loss of a chance doctrine. They advanced a loss of a chance claim at trial, but as I've explained, in relation to an entirely different matter. I've made my submissions in relation to that. They knew of the doctrine, but they chose not to apply loss of a chance to order to causation. And I've made my submission to the effect that Primeo made a clear litigation decision not to frame order to causation as loss of a chance. Having taken that gamble and lost, it's not now open to Primeo to come back for a second time. So for both of those two reasons, the position in Allied Maples is not analogous and provides no justification for the Sickers' decision to allow the point to be raised and then remitted. The final and fifth point we make at paragraph 246 of our case is that Again, this is a point that is responsive to a point the Court of Appeal made by way of justification of its decision. At the Sicker judgment at paragraph 333, the Court of Appeal said, quote, "It was incumbent upon the judge to apply the correct law when considering questions of causation and quantification in these circumstances, as it is equally incumbent upon this court to apply the correct law." But what that worthy sentiment fails to take into account are the principles articulated in the cases we've looked at regarding when new points can be taken on appeal and the need for finality in litigation. In our adversarial system, the court decides litigation by reference to how the parties have chosen to frame their case. There's no higher duty. The parties are required to bring all of their arguments and all their legal submissions before the court at the same time. That's necessary to avoid vexing defendants and achieving finality in litigation. In consequence, a court is neither required nor permitted, I would say, to allow new points of law to be taken on appeal when those points could and should have been taken below, and when further evidence is required to determine the new issue. So, my Lord, for those reasons, we invite the Board to overturn the Sticker's decision to direct a quantum retrial on the new loss of a chance case. My Lord, I'm now going to turn to our second ground of appeal.
Can I just inquire at this point if progress is being made on the preparation of the Scott schedule that we requested?
I'm told it's underway, but if it's not provided soon, it's not going to be much help, is it? Once again, I'll castigate my juniors.
Yes, it's simply to have the structure in front of us at a glance so we can see what the issues are, makes it easier for us to follow the submissions of both parties.
Of course it does. My Lord, I'm trying in my submissions to do a little bit of that. So, my Lord, can I now turn to our second round of appeal, which is the reinvestment argument. And we say that the Court of Appeal was wrong to overturn the trial judge by saying that it was not open to him to find that if Primeo had redeemed its Bilmis investments, because Primeo's accountants failed to give a clean pre-withdrawal audit opinion, Primeo would nevertheless have reinvested those monies on receipt of a post-withdrawal opinion with Bilmis through another Bilmis feeder fund. And my Lord, we say that that finding was fully open to the trial judge on the evidence. And we say that the Sicker's conclusion to the contrary was because, as an appeal court, it lacked a nuanced understanding of how Primeo had put its case at trial and lacked his greater understanding of the relevant evidence. And ultimately, the key point that I'm going to come to is that the judge's reasoning on this point was actually just an acceptance of how Primeo was putting its own case, save for the last stage. Primeo said they would have withdrawn and they would have invested in other US equity funds. The judge said no, and I explained the reason why he came to this conclusion. You would have reinvested back in Bilmis. And Sicker, in reaching its conclusion, didn't understand that 95% of the judge's reasoning was actually just adopting Primeo's own case. So we deal with this at paragraph 249 to 257 of our case. That's at page 2429. And Primeo's response is at paragraph 69 to 74 of their reply, which is at 2336. Now, just by way of reminder, can I start by looking at the key steps in the Sicker judgment? Because it's worth just laying them out so we understand the course of the argument. And the relevant paragraphs are at 336 to 341, page 308. So it's paragraph 336, Sicker correctly identified that the loss of a chance argument would only be relevant if it potentially affected the judge's conclusion that Primeo had failed to prove causative loss. They correctly recognised that that final link in the causal chain was to be determined on the basis of balance of probability, as it depended upon what Primeo would have done in one of two situations, either where EY had issued a clean pre-withdrawal audit opinion or where it had not. So at paragraph 337, Sicker agreed with the judge that in the first scenario, namely where a pre-clean withdrawal audit opinion had been provided, Primeo would not have withdrawn its investments. And that's not disputed. That's agreed. At paragraph 338, Sicker then agreed with the judge that in the second scenario, where no clean pre-withdrawal audit opinion was provided, Primeo would have withdrawn its Blimis investments. Now, again, for present purposes, that's not disputed. As one then sees from paragraph 339 and 340, the nub of the dispute is what would then have happened if there's no clean pre-withdrawal audit opinion. And first, at paragraph 340, Sicker said that it was not open to the judge because, quote, it fell outside the reasonable bounds of decision open to him to find that a post-withdrawal audit opinion would have been provided. So by that they mean an audit opinion which relies upon the subsequent receipt of the cash by Primeo as evidence of the existence of those assets at the balance sheet date. So that's the first point. The second point, which we see at paragraph 340, subparagraph 2, is they say it was not open to the judge to conclude that Primeo would have reinvested that cash with Blimis through some other feeder fund. So, my lords, I'm going to take those 2 points in turn, and I want to start by just outlining what we say was the trial judge's more nuanced understanding of how Primeo put its case, as compared to the Court of Appeal's understanding, which led the Court of Appeal wrongly to overturn his decisions. And there are 2 key points I want to emphasize. First, it was, as the judge appreciated, an implicit part of Primeo's case that if a pre-withdrawal audit opinion was not provided, a post-withdrawal audit opinion would be provided on receipt of cash. Second, it was an implicit part of Primeo's case that the failure of EY or some other auditor to produce a pre-withdrawal audit opinion would not of itself have excited a suspicion of fraud. So, can I start with the first of those propositions, that it was an implied part of Primeo's case that if there was no pre-withdrawal audit opinion, a post-withdrawal audit opinion would have been provided. And the starting point is to remind the board of the heads of loss that Primeo claimed. They claimed for 3 heads of loss, and we can see that from Sicker judgment at paragraph 304. First, the cash invested with Bilmis, which they said they would have withdrawn. That's the withdrawal hypothesis. Second, the future investments they would not have made. That's the no future investments hypothesis. And thirdly, and most importantly for present purposes, they were claiming the loss of profits they said they would have suffered through not reinvesting those monies in alternative investments. And there's no dispute, it can't be disputed, that at trial, Primeo claimed damages for each such head of loss. I'm going to concentrate on the loss of profits on alternative investments because that's what's key here. And that's why Mr. Illett, Primeo's quantum expert, dealt with the loss of profits on the alternative investments Primeo say they would have made. And that he dealt with at section 5 of his report. I'm sorry, I've not got the reference. I'll provide that. The trial bundle was D/4/47. I'll provide the reference. And secondly, it's why Primeo called, and the judge heard evidence from Mr. Thompson, who was Primeo's investment management expert, on how Primeo said that it would have reinvested these monies after withdrawal. He suggested various index-based funds structured around US equities or US fixed income funds. And we see that from Mr. Thompson's report at paragraph 5.15, and again, I'm sorry, I've not got the reference for the supplemental bundle. It was also the factual evidence of the main director they called, the discredited Mr. O'Neill. And we see that from paragraphs 125 and 126 of his statement, which we have at MS 1244. Now, when during closing, Primeo performed emergency surgery and introduced its auditor causation case, which at that time it pursued on the basis of a balance of probability, it still claimed damages under those 3 heads. But in combining auditor causation with a claim for loss of profits on an alternative investment, the judge rightly concluded that Primeo was assuming a post-withdrawal audit opinion would have been obtained on receipt of cash. So let me just unpack that slightly and then show you what the judge said. So, auditor causation only leads to a claim for loss on the assumption that a pre-withdrawal audit opinion is not provided. That's the case because everybody agrees that if a pre-withdrawal audit opinion had been provided, Primeo would have remained invested, obviously. So Primeo's auditor causation case assumes a pre-withdrawal audit opinion would not be provided. But Primeo's case was not that after having redeemed the Bilmerson investments and received the cash, Primeo would be wound up. Its case, as I've shown you, was that Primeo would have reinvested that cash in alternative investments. That was Mr. Thompson's expert evidence. But that could only happen, that could not happen unless, as the judge rightly recognised, Primeo's auditors then signed off the accounts using the post-balance sheet receipt of the cash as evidence of the existence of the assets at the balance sheet date. With that, can I ask your lordships to look at the judge's judgment at paragraph 259 and 26, which we need to read in conjunction with 267, because these are really the key paragraphs that SICA criticises. And in actual fact, what it does is it exhibits the judge's nuanced understanding. Well, it wasn't really that nuanced because, of course, he was the trial judge, and so he knew exactly how Primeo was putting his case. But it shows that he understood the implications. So, paragraphs again. Paragraph 259, which starts at page 144, and that has to be read in conjunction with paragraph 267. And those are the key paragraphs that SICA criticises at 339 and 340. So if I can start at paragraph 259. So paragraph 259, the trial judge is addressing order to causation. So one can see that because he starts the paragraph by saying what changed in Q1 2005 is EY lost confidence, and that then leads to the fact that there's going to be the custody confirms. So paragraph 259, we can see that the judge is starting to address order to causation. Halfway down that paragraph, he then says, faced with the possibility of being unable to comply with the statutory duty to file accounts, Primeo would have had no option to withdraw. So that is, using the SICA's terminology, absent a pre-withdrawal audit opinion, Primeo would have had to withdraw. In the last sentence, in that paragraph, the judge rightly says, implicit in this is the proposition that EY would then have issued, again using SICA language, a post-withdrawal audit opinion relying on the receipt of the cash in June as evidence of the existence of the assets on the 31st of December. So that is the judge's reasoning, recognising how Primeo is putting its case.
Can I just check, is the reasoning that, EY are Primeo's auditors, so yes, if they don't give a clean audit opinion for Primeo would have had to wind up the fund, yes, and just return, yes, whatever, yes, it had to, yes, its clients?
Yes.
Okay.
Yes, exactly. Because they were under, yes, that's exactly right. So with that as the background, can I go to paragraph 267? And basically, what the judge is doing here is adopting Primeo's own case on auditor causation and loss of future investments, save for the very last stage. So, putting it colloquially, he's saying, I accept your case that if EY had not issued the clean pre-withdrawal audit opinion, you would have withdrawn. And he's saying that on receipt of the cash, EY or some other auditor would have produced a post-withdrawal audit opinion allowing future investment. That was Primeo's case. But what he's saying is, in the last stage, I disagree with Mr. Thompson's evidence. You wouldn't have invested in an index-based US equity fund. You would have invested in another Madoff feeder fund. And that is because, as the judge says at the end of paragraph 267, this would avoid mass redemption by investors. And I'll come back to that because it's a critically important point, because the judge heard evidence of what would have happened if Primeo had tried to reinvest as Mr. Thompson suggested, and the judge concluded it would have led to mass redemptions, which would have created huge pressure on Primeo to continue with the Bilmus investments. So, Lord, that's the first proposition, the judge's nuanced understanding. Can I now turn to what I describe as being the second proposition, namely that it was an implicit part of Primeo's own case that the failure of EY or some other auditor to produce a pre-withdrawal audit opinion would not of itself have excited a suspicion of fraud. And, my lords, with the explanation of how Primeo put its auditor causation case, having explained how Primeo put its auditor causation case in combination with loss of profits on internal alternative investments, I hope I can take this point more quickly. Because Primeo was pursuing a claim for loss of profits on the alternative investments it would have made in the auditor causation scenario, it was implicit in that case that the failure to issue a pre-withdrawal audit opinion would not excite suspicion of fraud or wrongdoing. Because if it did, the reporting obligations that would have arisen would have precluded the withdrawal being made. So, putting it colloquially, if you don't produce the pre-withdrawal audit opinion, if people are meant to then think, oh gosh, this is very, very suspicious, that's indicating fraud, there would be reporting obligations, and so you couldn't withdraw it. That's not how Primeo was putting their case.
Mr. Gillis, before you go any further, I think you've gone a little bit fast for me. Can I take you back to paragraph 259, just to make sure that just to make sure I understand this. This is setting out Primeo's argument before the judge on causation. The plaintiff puts its causation analysis in the following way. First, it said that HSSL ought not to have issued the custody confirmation letter. Okay. Without that letter, E&Y would have insisted upon having access to Bilmus's books and records in order to perform their own audit.
I'm sorry, my lord, I'm having some difficulty hearing. I'm sorry.
I'm sorry.
I'm very heavily cold. I'm sorry.
No, it's, I have my head down. I'm just looking at 259.
Yes.
I'm following the plaintiff's argument that the custody confirmation letter shouldn't have been issued. Without that letter, so the counterfactual, without it, Ernst & Young would have insisted on performing their own audit procedures to confirm the existence of the assets. Madoff wouldn't have allowed that to happen, so E&Y would have threatened resignation. Fine. In these circumstances, it would have been very difficult to find another auditor prepared to accept the engagement on terms that it wouldn't have access to Bilmus's books and records or a custody confirmation. Fine. So, faced as a consequence of the foregoing, with the possibility of being unable to comply with its statutory duty to file audited financial statements, the argument is that Primeo's board would have had no real option but to solve the problem by terminating the relationship with Bilness and withdrawing the assets. Fine, I follow all of that.
Yes.
The last sentence, implicit in this argument is the proposition that E&Y would then have relied upon the subsequent withdrawal of the, in other words, the redemption, as evidence that the assets must have existed, thus enabling an unqualified audit opinion to be issued. Now, why is it said to be implicit in the argument? I'm sure the fault's mine, but I don't follow it at the moment.
Yes.
It's probably implicit in the next phase of the argument.
Exactly. Well, when he's saying it's implicit in this, it's implicit as part of Primeo's case, because Primeo were not saying in that situation we would have had to wind up and return our funds to investors.
It's
I see.
implicit in the withdrawal.
Right.
It's implicit in the fact that they could reinvest. In order to reinvest, they needed a clean audit.
Yeah.
Absent clean audit, they had to wind up the fund.
My Lord Hodge has it absolutely right.
Right.
Mr. Justice Jones expresses himself very succinctly sometimes.
Right, okay, I've got that.
But it's clear that particularly when you read that in conjunction with paragraph 267, it's very clear what he's saying. So, my Lord...
I must say I shared Lord Reed's difficulty when I first read
well, no,
259. It's very terse.
It is, and I accept that. I accept that. I would say it's well reasoned, but it's terse. It does require quite a lot of background knowledge to fully understand exactly sometimes what he's getting at. So, my Lord, just coming back to the point that it was implicit in the fact that Primeo was claiming for loss of profits on the alternative investment scheme in conjunction with auditor causation, it was implicit that they were saying that the failure to issue the pre-withdrawal audit opinion would not excite suspicion of fraud. And that's how Primeo framed its case, as they had to, if they wanted to claim loss of profits on alternative investments in the auditor causation scenario. And as Primeo said in their closing submissions, upon withdrawal, Primeo's knowledge would not have exceeded that of the defendants, and the defendants would clearly not accept that they had knowledge of Madoff's fraud. Now, on this point, Primeo probably found itself on something of a horns of a dilemma. If in the counterfactual, Primeo alleged that parties should have suspected fraud because of the inability to issue a pre-withdrawal audit opinion, that would have damaged its withdrawal case, because in that circumstance, the previous investments couldn't be withdrawn. But on the other hand, it would have strengthened Primeo's claim for damages for no future investments. Because if the failure to issue the pre-withdrawal audit opinion was an indication of fraud, well then yes, you could say, I wouldn't have made any further investments. But as I've shown you, Primeo framed its case as being for all three heads of damage, and in consequence, and to allow for that, put its case on the basis that no one should have suspected fraud. And consistent with that, can I show you a few passages where the judge made findings about the respondent's state of knowledge?
Just before, sorry, you go on to that, one thing that's slightly puzzling me at the end of paragraph 267, the idea of reinvestment in Madoff feeder funds, wouldn't that have led to the same audit problems as being invested in the original funds?
A good point, but no. What would probably have happened, and I'll play out the counterfactual, is that Madoff would have said, look, your auditors are being silly. Remove the cash, invest through Sentry, another feeder fund. Sentry is audited by PwC. They understand how things work in New York. So it wouldn't have led to the same problem, because you could have reinvested through a different fund which had different auditors, indeed different custodians, and that would have resolved the problems.
And was there evidence to support that?
I'm sorry?
Was there evidence to support that hypothesis?
But, well, there was evidence to support that there were other feeder funds, and there were other feeder funds that were audited by different investors, audited by different accountants, yes.
So your submission is there was evidence to support the judge's finding in the last sentence?
Yes. Yes, absolutely.
And was there evidence that those other feeder funds were getting clean audits at that stage?
Because of the fact that all of those feeder funds continued in existence until December 2008. So in terms of the suspicion of knowledge, if I can just deal with that as quickly as I can do. Paragraph 258. So paragraph, page 143, the judge says, the point about tipping off does not arise. HSSL did not suspect fraud or impropriety on the part of Bilmus, and it's not alleged that it ought to have done. Paragraph 258, the causation analysis is not based upon the premise that but for their breaches, the defendants would have become aware of the facts and matters which would have led them to make reports to regulators. And paragraph 278, the point about notifying the regulators is misconceived for two reasons. Firstly, the plaintiff's withdrawal hypothesis is not predicated upon the assumption that but for their breaches, HSSL would have become aware of facts which would have triggered a reporting obligation.
Which paragraph are you reading?
I'm sorry, that's paragraph 278. 278 at page 115.
Yes, thank you.
So, my Lord, what we say is that when Sicker criticised the trial judge's finding at paragraph 267 and said that it was a finding that was not open to him, what the Sicker did not appreciate is that this was, in fact, Primeo's own case, save for the very last step. It was Primeo's own audit causation case that they would have reinvested on the basis of a post-withdrawal audit opinion. Primeo said they would have invested in indexed US equity funds. Mr. Justice Jones said no, you would have invested back in a Madoff feeder fund to avoid mass redemption. Now, my Lords, with that as by way of the background and a lengthy background, and I apologise for that, can I now turn to the two limbs of the Sicker's criticism of the judge? And the first criticism, which we see at paragraph 340, subparagraph 1, there, Sickers say that it was not open to the judge to find on the balance of probabilities that a post-withdrawal audit opinion would have been provided. So, as we see from paragraph 340, subparagraph 1, the criticism of the judge is in effect an evidential one. They say there was no factual or expert evidence, and so the finding is speculative. And, my Lords, we deal with this at paragraph 254 of our case, at page 2430. And in the light of what I've said, I can deal with this quite briefly. There are 2 points I want to make. First, as the judge appreciated, and as I hope I've shown you, it was implicit in Primeo's own case that a clean post-withdrawal audit opinion would be issued. And as such, it simply doesn't lie in Primeo's mouth to say that the judge was not entitled to reach such a conclusion. It was, putting it another way, it was not open to Primeo on appeal to say that the judge was not entitled to accept their own case. Now, on this point, all Primeo says in its reply, and we see this at paragraph 72.1 at page 2336, what they say is, although Jones J seems to have thought that it was implicit, the basis upon which he thought this is unclear. Well, with respect, it's crystal clear. And Mr. Justice Jones was right in his understanding. The second overarching point that we make, now I will make this point rather than skip over it. My Lords, in this context, we say that it is interesting that in its written case before the SICA, Primeo did not seek to challenge the judge's finding as to the post-withdrawal audit opinion. And we have Primeo's written case at paragraph 100, in the supplemental bundle at page 139, and the relevant paragraphs are 179 and 180. And it's important to see that they weren't saying that the judge was wrong in concluding that there would have been a post-withdrawal audit opinion. And the reason they didn't say so, we say, was obvious, because at the time, Primeo was still pursuing its claim for loss of profits on alternative investments. And so the clean post-withdrawal audit opinion was a necessary part of that claim. And it was only when Primeo abandoned its claim for that head of loss, which was on day 3 of the appeal, that's day 3, page 102, lines 18 to 20, page 2054. It was only when it abandoned that it could then seek to adopt an entirely contrary position to the one that it took at trial.
Mr. Gillis, I've just been reading from 259 to 267, and what strikes me is that the focus of your argument is on the final stage of Primeo's causation argument. They say if A happened and B happened and C happened and D happened, it all ends up with Primeo reinvesting the proceeds of redemption in an alternative mechanism of some kind. And you're focusing on that very last stage of whether the question of whether they would have invested in an alternative or whether they would have put it into some other made-off feeder fund. But as far as I can see, the judge actually rejected steps A, B, C, D, and E before he got to that.
Absolutely. So
that's the icing on the cake, really.
So the judge rejected A, B, C, and D because he was being asked to deal with it on the basis of balance of probability. And because SICA suggested that they could pursue this claim on the basis of loss of chance, the fact that the judge had actually rejected A, B, C, and D doesn't actually provide the final answer to auditor causation plus loss of future investments.
Yes. Yes, I see.
My Lord, the second overarching point that we would make on this question of whether there could have been a post-withdrawal audit opinion is that if the judge had considered, or if material had been put before the judge because this was a live issue and it was a disputed issue and not common ground, there would have been ample reason for the judge to make the finding that he did. And I'll just take this briefly, but my learned friends, paragraph 72.2 of their reply, that's at 2337, they assert, by reference to no source material, quote, that as a matter of fact, auditors obtain evidence that the balance sheet gives a true and fair view at the balance sheet date, Evidence that cash exists at June 2005 is not evidence that securities exist at 31st of December 2004. With respect, we say with respect that's Primeo seeking to give expert evidence by way of submission. More importantly, it's incorrect. And the judge was a highly experienced member of the Financial Services Division, and we say it's fairly evident from his judgment that he was familiar and comfortable with basic accounting and auditing. And we've included in the authorities bundle the relevant guidelines on subsequent events. So that's, in terms of English accounting standards, IAS 10, which we have in the supplemental hearing bundle at page, supplemental 1, at page 656, and then the US Standard of Accounting, which is the Statement of Accounting Standard number 165, published by the Financial Accounting Standard Board, and that is the at supplemental hearing bundle 660. We've included the US standard because, in fact, Primeo's accounts were being audited to US GAAPs. And both of those standards indicate that you can take into account post-balance sheet audit evidence. And I'll take you very briefly to the standard itself, but applying those principles, one can easily envisage that an auditor, whether it's EY or some other auditor, is, if he's asked to provide a post-withdrawal audit opinion in April or May 2005, what would happen is that they are provided with evidence that the withdrawn monies are in Primeo's bank account. They're provided with bill misstatements from January 2005 to the date of withdrawal, showing the increase in the bill miss assets, and then would use the receipt of that cash as evidence that the receivable existed on the balance sheet date. And if I can just very quickly take you to the US standards. So if I can take you to the supplemental hearing bundle at page 670. And paragraph 8, the principle, paragraph 8, an entity shall recognise in the financial statements the effect of all subsequent events that provide additional evidence about conditions that existed at the date of the balance sheet. And then if I can ask your lordships to go to paragraph 9b on that same page, subsequent events affecting the realisation of assets such as receivables and inventories should be recognised in the financial statement when those events represent the culmination of conditions that existed over a relatively long period of time. So what we would suggest is that if you're trying to establish the value of the receivable on December 2004, you would be entitled to look at the fact that in March 2005 or June 2005, the cash was received. You can reconcile the amount of the cash received back to what the balance was on the balance sheet date, and on that basis, you can produce a post-withdrawal audit opinion.
Sorry to interrupt you. Is that your inference from this statement, or was that supported by evidence?
No, that wasn't supported by evidence because, as I've indicated, my lord, the point was not an issue.
I see.
Because it was Primeo's own case, necessarily, if they're combining audit causation with claim for future investments.
But would it be permissible, if we were in any doubt about that submission, that prior submission, to refer to this kind of a document in support of the submission that you're...
In our submission, in the totality of circumstances, it would be, because what the Court of Appeal were saying is that it was not open to the judge to reach this conclusion. And in our circumstance, in our submission, when one actually looks at the gist of the gap provisions, there is provision to allow subsequent events to be used to validate balance sheet date valuations. But, my Lord, I fully agree that the position is not terribly satisfactory, but it's in consequence of the fact that it was never an issue. And as I said before...
Well, I understand that submission.
Yes. Yeah. So, my Lord, with respect to SICA, they didn't have the judge's nuanced understanding of how Primeo put its own case, and we say they were wrong to say that the judge's decision on the post-withdrawal ordered opinion was one that was not reasonably open to them. My Lord, can I then turn to the second point where SICA criticised the judge, and that was we see this paragraph 340, subparagraph 2 and subparagraph 5, and they say that it was not open to the judge to conclude that on receipt of a clean post-withdrawal ordered opinion, Primeo's directors would have reinvested through another Bilmis fund. And the totality of the SICA's reasoning on this point is set out at paragraphs 340, subparagraphs 2 to 5. That's at page 310. And before I get into the detail of that, can I just make two very obvious opening comments about those paragraphs? First, SICA did not say the trial judge made an error of law or failed to take account of relevant evidence or took into account irrelevant evidence. Rather, without setting out what they regarded as being the totality of the evidence that was available to a reasonable decision maker, they simply said that the decision was one that was not reasonably open to him. And that, in our submission, is unsatisfactory. In a complex case such as present, it leaves open to doubt whether the appellate court had properly understood the trial judge's decision-making process and properly evaluated the evidence he took into account in reaching that decision. The second point we make is that there's nothing in SICA's reasoning on this point that was not known to the judge. All of the SICA's reasoning on this point flows from the failure to issue a pre-withdrawal ordered opinion. Now, I'll come to the conclusions that can be drawn from that, but the judge was fully aware that that was the premise of the reinvestment point. That's clear from his judgment at 259 and 267. And in our submission, the suggestion that the trial judge reached a decision that was not open to him, despite the fact that he was specifically considering the relevant scenario, is highly unlikely. Now, my lords, with that, can I just start by looking at the SICA's reasoning for why they say the decision was not open to him. And we see this at paragraph 340 at subparagraphs 3. And the point at SICA 340.3 is simply that because of Madoff's refusal to give the auditors access or provide them the documents they required, the auditors would have been unable to provide a pre-withdrawal audit opinion confirming the existence of the assets at the balance sheet date. And then at subparagraph 4...
Before we go on to 4, in 3, the assumption is that Madoff would have refused them access, but the judge found that Madoff would have allowed access.
Yes, but again, you know, we've moved from the bounds of probabilities to loss of a chance. Yeah. Yes.
So it's not only that the judge has. So the judge would have to go back and when he found as a fact. Where is it? Paragraph 261, last sentence. For all these reasons, I'm not persuaded that Madoff would have refused to give Ernst & Young access to Bilmis's books and records. So the loss of a chance would require him going back and estimating what the probability is that Madoff might have done.
Absolutely so.
And
so
he has to do the same for every step in the argument.
Exactly so. So we would, in effect, have determined, by reference to different evidence in front of a different judge, because Mr. Justice Jones has now retired, a reconsideration of all of the points that the judge has made decisions on. So, and that's the point that we make at paragraph 233 of our case. But, my Lord, going back to the Sicker's reasoning, paragraph 340, subparagraph 5, what we say is that without really articulating the reasoning, Sicker say that because the auditors would not have been able to verify the existence of the assets on the balance sheet date, it was not open to the judge to conclude that Primeo would have reinvested on receipt of a post-withdrawal audit opinion. Now, Sicker don't actually say why the one flows from the other. However, the only reasoning that would explain why one flows from the other is if the inability to issue the pre-withdrawal audit opinion showed that there was a real risk that the assets did not, in fact, exist. In other words, it's a conclusion that only flows if you say that the consequence of the auditor's inability to issue a pre-withdrawal audit opinion is that people should have recognised that there was a risk of fraud, or you were put on notice. Now, if that was Sicker's reasoning, one can sort of understand the logic, because obviously in that circumstance you wouldn't have reinvested through another Madoff feeder fund. But the key point which the Court of Appeal, the Sicker, failed to appreciate is that's not how Primeo was putting its case. Primeo's case was the exact opposite. As I've shown you, and as the judge appreciated, it was implicit in Primeo's case that the inability to issue a pre-withdrawal audit opinion would not have been viewed as an indicia of fraud, thereby triggering reporting obligations and therefore preventing withdrawal. Rather, it was Primeo's own case, as it had to be, combining auditor causation with loss of future investments on alternative investments, that a post-withdrawal audit opinion would have been provided and wouldn't have excited suspicion. And we say that once it's appreciated that it was Primeo's own case that the inability to issue a pre-withdrawal audit opinion would not be regarded by the Primeo directors as a red flag for fraud, the judge's conclusion was one that was fully open to him. In essence, all of this depends upon the evaluative judgment of how Primeo's directors would have reacted to the fact that EY was unable to produce a pre-withdrawal audit opinion, possibly because Madoff refused them access, but then was able to and did issue a post-withdrawal audit opinion. And in our submission, as soon as the issue is stated in those terms, in our submission, it's clear that this type of issue is one that is preeminently for the trial judge, not the appellate judge. It depends upon how the Primeo directors and investment advisors would have risk-assessed Billness in the light of the new information. And it also depends upon the assessment of the investment evidence that the judge had heard in terms of how difficult it would have been to reinvest in alternative US investments, which would have prompted mass redemptions.
I follow your point about evidence about how the directors would react. Wouldn't it also depend on evidence about how EY would react? So in answer to my Lord, yes. Lord Hodge, you talked about the accountants of the feeder funds, but of course we're concerned with EY as accountants of Primeo.
Yes.
So, and Primeo needs a clean audit opinion from them, so they would need to be satisfied as well that it was going to work, yes. Going through another feeder fund.
Exactly. And on that, there is no evidence in terms of what they would have done or what dialogue they would have had with the directors of Primeo in order to get everybody comfortable. So, my Lords, we do say that if one has regards to the totality of the evidence that was before the trial judge, it was, because it was fundamentally accepting Primeo's own case, apart from at the last stage, it was a decision that was fully open to him on the evidence. My Lords, just... I'm going to be another 5 minutes, if I may, before I finish this point.
Well, I think we'd rather hear you at 2 o'clock.